Good afternoon, everyone.
Good afternoon, Judge.
How's everybody doing? Pretty good.
I think people are doing well.
All right, good. All right, we're going to start. It's a small magistrate docket for this afternoon. So when I call your name, please come forward. And we're going to start with Ari Portal. Ari Portal, whose family is here just for the record. Is that accurate?
Judge, Ari Portal's here at Maine, and he declined the services of public defender.
Thank you very much.
Thank you.
And Mr. Portal, good afternoon.
Good afternoon.
Thank you. Sir, you've been arrested on one count of battery, domestic violence. Just for the record, I've reviewed the probable cause affidavit. I did find probable cause. You do have a bond. Counsels, I was going to set the bond, this misdemeanor offense at $500. Order no contact, direct or indirect, to the alleged victim at this time. Thank you very much.
Thank you.
You done? Outside, go down the middle.
Did anybody want to say anything? Did anybody want to say anything? Anybody want to say anything?
Precise.
Do you have an attorney?
I set a bond at $500. There's a charge, domestic violence, there's an arrest, domestic violence battery. Formal charges have not been filed as of yet. I can't give any legal advice. I cannot give any legal advice. Can you ask the jail? It's very noisy in the jail. I can't hear.
I'll mute it.
Oh, thank you. Thank you. I'm sorry. What did you say? I'm sorry.
I was just saying, she didn't press charges.
Okay, you can't comment, and I can't comment about that. All right? Thank you very much. Brent Weedbush.
Judge,
There's a
Mr.
no
Weedbush is
contact
here
order in place.
present.
Thank you. Yes?
Judge, Mr. Weedbush is here present at Maine. He also declined the services of public defender.
So noted. Thank you very much. Good afternoon, sir. You've also been arrested on one count of domestic violence battery. I did find probable cause. There is a bond. Bond is set at $500. I'm ordering absolutely no contact, direct or indirect, with the alleged victim. Thank you very much.
Thank you.
Jesper LeBrun.
Mr. LeBrun is here present, Judge, at Maine.
Thank you very much. And sir, you have been arrested on one count of domestic violence assault. And I wanted to say something about this PC affidavit. Respectfully, I'm not really able to make a very clear finding. It's a very conclusory affidavit with not too much detail that, I'm not really clear about. There's no context to this.
The only thing I would say, Your Honor, is I don't know that it's necessarily conclusory in that I would agree if it just said he threatened her, and that it's
That's
conclusory.
pretty much what it says.
But he threatened to kill while chasing someone around the house and onto the street, and saying that she's screaming for help as she's fleeing, which would indicate.
But that's not a very typical affidavit in the sense that typically you have some context in terms of a factual context. That gives some. I'm just simply saying, is there,
I understand, Your Honor, but at the end of the day, for element-wise, somebody physically chasing someone, threatening to kill them, I think
I'm going to find probable cause, based on that. But I would just simply say, it's kind of weak.
No, I understand that more details would be
thin. I'm just simply saying it's thin, and I think that it's more of a comment, I think, on the law enforcement officers' detailing of a report or lack of details of a report. But you're right. I agree in terms of your comments that the core elements are there. but I'm just letting you know. I think it could be more. I think it could be a stronger probable cause affidavit.
I don't necessarily disagree with the court as far
That's
as that
all I'm
goes.
saying.
Also.
And could I just get a suggestion, some guidance from the parties, please?
Your Honor, well,
Yeah.
he does have a 2012 DUI. Even without the details, I'm always a little concerned when I see allegations of threats to kill. Your Honor, I would be asking for, and I understand it's a second-degree misdemeanor, but that being said, I'd be requesting a $2,000 bond and no victim contact.
Okay. And
I know for fiction everything.
Judge, respectfully,
Yes.
in speaking with Mr. LeBrun, he's 59 years old. At this point, he's going to be living separate and apart from the alleged victim, which is his wife. He'll be living with his daughter, who resides in Fort Lauderdale. Judge, I would be asking you, considering this is a second-degree misdemeanor, even though you found probable cause for mitigation purposes, I would ask you to consider at this time a $100 bond on Mr. LeBrun's behalf.
okay, that's denied. All right, I'll set bond at $1,500 based on the nature of the allegations. No contact, direct or indirect.
Would you sign a phone order, Judge?
For access to a telephone, yes, I would.
Thank you, Judge.
Did you say? I'm sorry. You said phone or photo?
Phone order.
A phone order. Yes.
Thank you, Judge.
Next, I have Navin Singh.
Mr. Singh is here present. Judge, Mr. Singh advised me he has private counsel. His attorney...
Okay. Mr. Singh, that's fine. I'm just letting you know nobody's here for you at this particular hearing. And I have a legal obligation to magistrate you unless he wants to be reset in the morning.
It's up to Mr.
That's
Singh.
really up to you.
One more time?
Did you want me to reset your hearing for the morning?
No.
Okay.
That's fine. Today is fine.
Your Honor.
Okay. Yes, sir.
I
did go over
Yes.
all of the paperwork that you
I'm just making a record that I did provide the court with paperwork and a
just for
copy
the
of the
record,
information.
I have arrest affidavits. I do have a police narrative as well as an information.
And Your
Two-count information.
Your Honor, count one is a punishable by life offense. The state is seeking a no bond hold. Unlike the cases we had earlier on our docket today, the state has provided supplemental reports, a transcript of the victim's sworn statement. Your Honor, I would ask that would support a finding.
And the charges are filed.
Yes.
This is not an arrest.
No, I know. I'm just stating what. I'm just making a record of everything I specifically
You know,
provided to the court.
it wasn't an arrest. I did walk myself in this morning.
Yes, but the formal charges have in fact been filed, whereas it's typical for this at this phase. More often than not, people have just been arrested, whereas no charges have been filed yet. So I'm just drawing a distinction. That's all.
I understand.
All right.
And that is another distinction, Your Honor. You're correct.
Okay, thank you very much. And as to count one, the burglary with assault, I'll enter a no bond hold with a $1,000 bond, no contact, direct or indirect, with the alleged victim, which includes the children. Thank you very much.
That's it? That's what I have my bond $1,000.
Sure. And just for the record, I would appoint a guardian ad litem on behalf of the children, although I did see that it was referred to the department within the body of the police report.
If that, and Your Honor, now that it's filed, he'll be arraigned soon. If that's an issue that needs to be resolved, we'll take care of it.
Absolutely. Absolutely. Thank you, sir. Stephen Noller or Noller?
Mr. Noller is here, present judge at Maine. He is approaching.
Thank you. I'm going to ask for priors.
Yes, Judge.
Mr. Noller, you have been arrested on one count of domestic battery by strangulation. Very serious allegations, and I did find probable cause. I'm going to ask the state, please, for any prior criminal history.
Your Honor, and this is his history out of Broward. 2006, he was convicted of burglary of a dwelling and theft. He was sentenced to 7 years state prison. A trespass in '03, unlawful use of false name ID '01, burglary of a dwelling '93. He was sentenced to 9 years state prison. Burglary of a dwelling '91. He was sentenced to 5 years state prison. Burglary of a dwelling '91, sentenced to 5 years concurrently. 1990, purchase of cocaine. 1988, burglary of a structure and grand theft. That concludes his Broward history, Your Honor.
Judge, and speaking Mr. Noller, he is 51 years old, been residing here 48 years. He is working. He works for DLP Industries. He's been working with that company for 4 years on the assembly line. He makes approximately $16 an hour. Judge, we'd be respectfully requesting you to consider a bond of $2,500 on Mr. Noller's behalf.
Bond is set at $10,000. Motoring no contact, direct or indirect. Motoring pretrial release with a GPS ELO monitor. No contact, direct or indirect with a 500-yard restriction from the alleged victim. Thank you. Charia Tammy Johnson.
That'd be North Broward, Your Honor.
Thank you.
How you doing, Miss Lerner?
Hi, Tammy. I just saw you this morning.
Yes, maybe you didn't know about the other charge, but I had one more. Trespassing.
Do you want to resolve it? I would have resolved
Yes,
it
I'd
this
like to
morning.
resolve
I'm
it.
sorry. Just a withhold, no adjudication, no conviction. Okay?
Is that the only charges I have, ma'am?
I don't know. I hope so.
You took care of her charges this morning. Yesterday.
I did.
That was an ad charge.
Yesterday? Was it yesterday? Oh.
So those are all my charges, ma'am?
Yes.
So I will be going home today?
Yes.
Okay, thank you very much, Judge Lerner.
You're welcome.
Go ahead, Tammy, back at cell one.
Howard,
you're next.
Bernetria Howard.
North Broward again.
Thank you.
The next three are at North Broward, Your Honor.
Got it. Thanks. I appreciate that. Ms. Howard, I have 3 outstanding capiases for petty theft, and I'm thinking maybe you might have missed a court date. I'm not really sure if that was for failure to appear.
Like when it happened, like I went to jail behind both, like whatever I did, and then like my mom called to see
Three
if
separate court dates.
3 separate cases.
3 separate dates, yeah.
You have a place to live or you do not?
No, I'm homeless.
You're homeless? Were you in foster care?
No,
No?
no.
How long have you been homeless for?
Like I just became homeless. Like I've been homeless for maybe like 3 months.
Any family?
Yes, my mom.
And you can't stay with her?
She won't let me, but I don't know because like when I got arrested, I was sleeping in Walmart parking lot, so. And that's how I knew about that I had a warrant. I didn't know.
Okay.
Because I was young then and I haven't been in trouble since I did those charges or whatever.
Okay. You know, you can go into the the Salvation Army. You could actually walk into the Salvation Army and they can try to assist you. I'm not saying that they would necessarily have beds, but they would certainly assist you. That's one way. And you know that I don't know if you know, and it would be, you know, hopefully, you know, maybe your family could pitch in a little bit. Are there tires? What else is going on?
I just see these 3 cases.
All right. If you want to resolve them, you can. I'll offer you a withholding of adjudication, no conviction. I'll convert any costs for you.
What does that mean?
I'll convert them to a civil lien. If you want to resolve your case by plea, the offer of sentence is a withholding of adjudication on all counts. You don't have to accept that plea. You do have bonds. Your bonds right now are at $1,000. The offer of sentence is a withholding of adjudication on all counts. No adjudication, no conviction, no return to those locations.
Okay.
So what would you like to do? Do you know?
What did you say? I wouldn't have to go back to those locations where I stole the items from?
Where you got arrested?
Yes, ma'am.
She wouldn't be allowed to return.
No return to those locations, correct?
Okay, no problem.
Okay, you're all set. Thank you very much. All right?
Okay, thank you.
Try to get to the Salvation Army.
Okay, thank you.
Oh, sorry. Cynthia Duvest.
Hey, good afternoon. How you doing, Judge?
Good. How you doing? What's up?
Not too fine.
Not too fine? Do we know each other? Have you been in my court?
No, first time I'm just meeting you. I'm just hoping you're in a good mood today, and also you make exception, and you work with me because I made a stupid decision yesterday.
Well, don't talk about anything, all right? Don't say anything. Anything you say will be used against you. And just for the record, you have been arrested on 2 counts of driving under the influence, and I did find probable cause, and you do have bonds, and your bonds total $1,500. Could you make a bond?
I can't. I'm not gonna lie to you, ma'am. I can't.
Judge, may I say something on her behalf? Judge, she's lived here in South Florida for 31 years, and she has family here. She does work for a security company, but she doesn't have any help for bond.
Okay.
Please.
Please what, ma'am?
Can you make it? Judge, can you make the exception, please? Please. I've never did this before.
I don't see any priors, Judge.
Traffic. Do the traffic record, please. And what county do you live in?
Miami.
What part of Miami?
They call it Little Haiti. Off of 68, but when you get off of 79, it's on the east side.
Mm-hmm. State 189, 186.
Oh, I was just speaking to our victim
In
advocate.
the bushes.
On her way, allegedly on her way to work.
So I'm not going to, I'm happy to reduce a bond if you want to know the truth. I'm very happy to do that. I have no objection in reducing a bond. I'll reduce the bond to $500. But I'm not going to, certainly not going to ROR, and I'm not comfortable with a PTR.
And, Your Honor, we just asked for an additional condition, no alcohol or intoxicants.
Say again.
No alcohol or intoxicants, please.
Sure. Special bond conditions, ma'am, no alcohol, no intoxicants.
You can't look at me. I can't give
Okay,
you, I can't
no,
give you legal
mean
advice.
it.
Don't drink alcohol.
Okay, not a problem, ma'am. I
Don't
won't
drink alcohol. No
Yes, ma'am.
intoxicants. All right?
Yes, ma'am.
All right,
Yes,
thank
ma'am.
you very much. Try to bond out. Good luck. Thank you.
All right.
I'm reducing. I'm going to delete the 1,000. I'll do 500 on each count. 501, 502. Oh, strike
So
that.
that means
250. Excuse me. Just ROR on the simple. ROR on one, 500 on the other. All right. Thank you. Yvonne Christina Garcia.
You got a
Thank you very
$500
much.
bond.
that means I have to
You
pay.
got to come out. I got the next one coming in. I'll explain it to you in a second. Give me a minute.
Thank you.
Garcia, North Broward.
Ms. Garcia, Good afternoon. You have been arrested on one count of battery, one count of assault, one count of resisting or obstructing without violence, one count of corruption by threat of a public servant, one count of leaving of the scene, one count of operating without a valid license. And just for the record, I did find probable cause, and you do have bond. State, a little guidance, perhaps from your view. I set bond at 1,000 on count one, 1,000 on count four. Total bonds are 2,325 for all counts.
Does pretrial have any notes as far as priors? She has no Broward priors from what I can tell. I mean, it's an unusual report. When I opened it, was expecting to see either the alcohol or the drug influence box checked off, but neither was. Now, that doesn't mean she wasn't under the influence, but this is just unusual. The threats to kill, threat to kill an elderly woman.
How old are you?
22.
Where's your family?
At home, and I'm gonna lose my job because I'm here.
Where's your? Can you call your family?
They're not giving me a phone call, and I'm not suicidal, and they have me in this.
Yeah, they do that for a precaution.
I had never been suicidal. I'd never been arrested.
Well, do you have a phone? Do you have a phone in your? Could you call your family?
Can you please let me?
Yeah. Why can't you call your family?
I've been asking and they're not letting me.
They will. They will. So are you, can I ask you, State, from your vantage point, are you looking for the court to
I think
modify what I was thinking?
Well, I was thinking, I don't know, some sort of combination of bond and maybe some other services might be appropriate in this situation.
Okay, I can do that too. So why don't let's see, give me 1 second. Just trying to get some input, 1 second. Do you happen to have a driving record on her, madam?
Why didn't she release me? I don't know.
1 second. No license. Okay.
Exactly. I got you some right.
5.78.
Did you want oil and vinegar and all that stuff? Okay, that's what I did. I was like, you said everything. I put it all in there.
Yeah, they told me.
If it's mine, I take it out of both sides. If it's mine, you take it out of one. Maybe something mine. All three of them.
Okay, so this is what I'm going to do. I'm going to set bond at $600. I'm going to order her on pretrial release. It's $500 is to count one, $100 is to count two, ROR and all other counts. Pretrial release. She needs to report to pretrial release upon bonding out. Absolutely no driving. No driving without a valid license. She does not have a license according to her Florida driving record.
I have a Texas driver's license.
No driving without a valid license. No alcohol. No intoxicants. Random screens. 1 second. One thing that is, the affidavit's kind of an inverted affidavit. if you know what I'm saying. It's focusing on the
It covers
post.
each element, and it covers each element
That-
of the offense, but not the underlying.
Right, we don't really know much about the upfront factual pattern.
No, and
so
that's why-
it's very hard for me
yeah.
to figure out what might, if there was potential causation, if it was alcohol, drugs, or mental health. I can't really
And hopefully,
figure out what the behavioral health issue might be, if there is a behavioral health matter.
and hopefully, as the state gets more reports, that information might become clear, and then
But
down the road,
why
it can be
don't-
dealt with.
but-
My main concern, Your Honor, at this point is, certainly if a no contact order could be issued for, Esther Cardenas, because going forward, that's, I think, one of the most important things here, to make sure there's no contact between the two.
No, yeah, most definitely no contact with an Esther Cardenas.
I don't know her.
Then it shouldn't be a problem.
And it won't be, that's right, it won't be a problem. And no driving, obviously without a valid license, no alcohol, no intoxicants with random screenings. So when you are released, ultimately, when you are able to post some bond, then you need to report to pretrial release, all right?
Can I please make a phone call?
They're gonna let you make a phone call, ma'am. They will. All right? Thank you very much. Good luck. Erica Abraham.
She is a med reset, Your Honor.
Thank you.
Your Honor,
Yes?
just to bring to the court's attention, and it's up to you,
Sure, of course.
this is just a change of charge. It's an upfile from a robbery by sudden snatching.
So noted.
I'm just checking to see when her arraignment date is, because all I was going to be asking the court to do was to set the bond that was originally set.
Sure.
It was originally set at $5,000. She's got very large bonds on other charges, so.
Yeah, this just for the record, this is count 15. Count 15, I will go ahead and set bond at 5,000, no change. For the record, no change in bond. Jacob Alexander Johnson.
You can't say later on down the road, I didn't know I owed
Jacob
money.
Alexander Johnson. Anybody? Anywhere?
They're looking right now for him, Judge. If he might have posted bond. Johnson? Oh, he's here. Jacob. He was here, Judge.
Hello?
Ma'am, how you doing, ma'am?
Fine. Sir, you have an outstanding KPS on a trespass. If you want to resolve your case today, you can. The offer of sentence is adjudication credit, time served.
Let the judge know if you want to accept it.
Yes, ma'am, I accept that offer.
All right, thank you very much. No return to the location where you were arrested. Thank you.
Yes, ma'am.
Done.
And of course, give him 6 months to pay. Antonio Dwight Mills.
That is a med reset, Your Honor.
Thank you. Kervin Keith Eccles.
Yes.
He's here present, Judge.
Thank you. Sir, you were arrested for 1 count of trespass. If you want to resolve your case today, you can. The offer of sentence is withholding of adjudication and no going back to that Motel 6.
Yes, ma'am.
You can't go back
Yes.
there. And I'm not going to accept the plea if you think it's funny.
Oh, no, I was just smiling, man, because you was letting me go. I'm not thinking it's funny.
Okay, please don't go back there. All right, thank you very much.
Mm-hmm.
You're all set. Torrance Gerald McDougall.
Mr. McDougal, come on up, please.
Thank you. Sir, you have a child support writ in the sum of a purge amount of $399. So in the event you cannot make that payment, you will have to see the family law judge or the department or the magistrate. There's also an outstanding KPS on a traffic matter, a driving while license suspended or revoked. If somebody can give me a driving record, maybe I could resolve it.
From what I can tell, Judge, just let the court know, I'm showing a couple of operating withouts. Yeah. Actually, I'm showing one
Prior
operating.
DWS?
No, prior DWS is just an operating without in 2013, from what I can see.
If he wants to resolve his case, he can. It would be adjudication, credit for time served. No driving without a valid license. No driving. And it's important.
Yes, I would like to resolve.
That's fine, but it's really important to understand, sir, that under the laws of the state of Florida, if somebody has 3 or more driving while license suspended or revoked charges, that person will not be able to get a license for 5 years or lose a license for 5 years, and if there's any subsequent offenses, could be charged as a felon. There's like a 3-strike rule, so it's really important. If you want to drive, you have to get a license, correct?
Correct.
All right, excellent. Thank you very much. Yes.
She resolved your case.
Thank you.
Eddie Johnson, traffic.
Mr. Johnson's here present at Main, Judge.
Thank you.
Good morning, ma'am.
Good afternoon, sir. And Mr. Johnson, you were arrested for 1 count of driving while license suspended or revoked. If you want to resolve your case today, you can.
Your Honor, the only thing I would ask you advise Mr. Johnson, I'm showing he has a pending possession of heroin, felony theft, and trespass. He just has to be advised pleading this case out could have an effect on that case. I don't know what it could be, but as long as he's aware.
I'm understanding that you have a serious drug charge pending. If you resolve this case today, it could have a negative implication on the outcome of the felony case in terms of sanction. I was going to offer you a withholding of adjudication, no conviction. There's been no recent pattern of driving.
Well, you want, yes, ma'am. I take your offer.
Yes, my just to clarify, can you hear me okay? Are you able to
Well,
hear?
I can hear you, ma'am, but I don't even know what y'all are saying.
Okay, well that's fine. I'm happy to explain it. So what I'm saying is you have a traffic matter pending, a charge pending of driving while license suspended or revoked.
Yes.
I looked over your driving record, and I've noticed that for the past decade, I've not seen any traffic charges or citations on your record, and therefore, I was offering you a withholding of adjudication, meaning it's not a conviction, it's not an adjudication against you. I'll take judicial notice of time served. The issue that the state was raising is you have a serious charge pending, a drug charge, and this could, implicate that charge. That's all he wanted me to advise you.
Oh, well, yes, ma'am. I take your advice,
Well, I'm not really advising you. I'm just explaining to you. It's up to you whether you want to accept that. So did you want to resolve this case or no?
Yes, ma'am. Yes,
okay,
ma'am.
fine. You're all set. Thank you.
Okay, thank you.
Poor thing.
Thank you, Judge.
Sure. Jamil Lockhart Houston.
Yes, ma'am. Mr. Houston's here present at Main.
Thank you. Sir, you have been arrested on 1 count of aggravated assault with a deadly weapon without intent to kill, 1 count of aggravated battery with a deadly weapon, 1 count of carrying concealed weapon, 1 count of a possession of weapon by a convicted Florida felon. And just for the record, I did find probable cause on all counts. These are serious allegations. Just for the record, aggravating probable cause affidavit. And I was simply going to ask the state, in terms of Any recommendation for the court?
Your Honor, I'm very concerned based on these allegations, not just the alleged use of a firearm and the violence entailed, but also allegedly the defendant pulling a firearm when a child was present and putting that child potentially in harm's way. Additionally, what's causing me great concern is Mr. Houston's criminal history. 2000, burglary of a dwelling with a violation of probation, 17 years state prison. 2000, possession of firearm by convicted felon. Theft with a violation of probation, 17 years state prison. 2000, manslaughter with a violation of probation, 17 years state prison. 98, possession of cocaine with a VOP. Additionally, Mr. Houston was convicted at I'm not sure if it's Levi or Levy County in 2004 of strong arm robbery and sentenced to 10 years state prison. Your Honor, based on the level of violence alleged in the report and a history of violence where he was just released from state prison in April 5th, 2015, I'm going to be requesting a $100,000 bond on counts 1 and 2 and $50,000 bonds on counts 3 and 4. Should he be able to post his bond, I would be asking for a supervision of pretrial release with a GPS monitor, and I'd be asking for level 1 supervision.
Could you clarify?
Yes, Judge.
What you just said with regards to, I got the 100,000 as to 1. What did you say? Can you
100,000 on 1 and 2.
Okay.
And 50 on 3 and 4.
Defense, did you want to comment?
Yes, Judge. And speaking with Mr. Houston, he's been residing in South Florida his whole life. He is 38 years old, Judge. He is currently working. He works at Bacadard Condominium. He's a maintenance worker. He makes approximately $10 an hour. He just got that job. Also, besides that, Judge, he's also currently going to school. He's going to Atlantic Tech. He's studying carpentry. He does have exams tomorrow. What he's trying to do is trying to get educated so he can get a better job and be more productive. I did advise him, Judge, he wanted to get into issues of fact. There's always two sides to the story. I told him this is the appropriate forum. He'll have his day in court, but he will be disputing the facts, and he's looking forward to this day in court. He lives with his mother. He's been residing in the same location for 2 years. He lives in North Lauderdale. Financially, though, he has no money, he has no property, and his mom has limited income. Respectfully, we'd be requesting a bond on count 1 of $5,000, on count 2 of $5,000, and on count 4 of $5,000, which would be a total of $16,000, Judge. That's what the defense would be asking at this time.
Okay, you can't do that. Can't do that. Bond is set at $300,000. Thank you very much.
Can I speak, Judge, please? Can I?
100 on 1, 100 on 2, 50 on 3, 50 on...
Judge, respectfully, Mr. Houston would like to address the court. I told him not to talk about the facts of the case.
Excuse me, ma'am. With all due respect, my past, the last time I got in trouble, I was 25 years old. I'm 38. I'm a grandfather. I've been going to college since I've been home. I've been working since I've been home. I've been accused of a crime, but I'm a changed man. I know my past, my criminal past. It does sound bad, but I'm actually a completely changed man. I've been, like I said, I'm worried about my exam tomorrow.
Thank you very much. I appreciate what you're saying. Thank you very much.
Yeah, we just asked for an order of no victim contact, please.
No victim contact, direct or indirect. You could certainly apply to your circuit judge for any bond modification. Thank you.
Yes, ma'am.
Darrell Roger Baker.
Thank you.
Mr. Baker's here approaching judge. Oh, he declined the service as public defender.
Oh, so none.
I didn't.
Oh, he didn't. He's saying counsel.
Okay, well.
Just for the... Oh, sorry. They're consulting.
They can hear you.
But they're consulting. I don't want to interrupt.
But I didn't do it.
You stop. We're waiting on the judge.
Hey, good morning.
Yes, thank you. Sir, you have been arrested on 1 count of aggravated battery on a pregnant victim one count of false ID given to a law enforcement officer. There is a violation of probation that was triggered by these allegations. I did find probable cause. So you will have to see your division judge on May 4th. I think that's Thursday at 9 a.m. I am setting bond as to count 1 at $5,000. There's $100 bond as to count 2, so $5,100 as to bonds as to count 1 and count 2, and no contact.
Thank you, ma'am.
Thank you, and just one last thing. I'm sorry. No contact, direct or indirect, with the alleged victim. Thank you.
Thank you, ma'am. Enjoy the rest of your day.
Good luck. Christopher Lopez is next.
Your Honor?
He's here at Maine, approaching.
If I could address the court, both on Mr. Lopez's case and Mr. Santana's case before the court makes any
they're
determination.
co-defendants?
Yes.
Yes. Did you want me to ask both of them?
You know what? How about we'll do it one at a time? The jail might not want both.
Oh, okay,
Your Honor,
sure.
I was going to be requesting that this could be reset for determination for 24 hours. I'm trying to reach either Detective Copley or Detective Ramirez, who have been assigned to the case. I haven't been able to reach them yet.
I don't have any objection to that.
So I just asked if it could be reset for tomorrow afternoon, please.
Counsel, did you hear?
I did hear.
They're just, state is asking for a reset to tomorrow afternoon. I don't have any objection to that.
I know. Under the rules of Florida criminal procedure, state can ask for 24 hours in order to perfect probable cause. If that's their intent, there's no legal objection. That's their right. But I don't know if that's the reason why they're asking for the extension.
The reason I'm asking, Your Honor?
I don't think that's the reason. I'm very fully prepared to find probable cause after my review of the affidavit. I'm not sure what their reasoning is. I didn't really feel like I needed to ask, quite frankly.
And Your Honor, I'm referring to Rule 3.133A, which is the non-adversarial probable cause determination, which states that probable cause determination has to be made within 48 hours from the time of the arrest. We're currently at about less than 24 hours. So under the rule, as long as it's made within 48 hours, and that's why I'm just asking to be reset for tomorrow so that I can provide the court with more information.
That's fine.
Judge-
I'm not making a no probable cause finding.
Yeah, no, I understand. That's why I'm just citing the rule. That's all.
But Judge, if we have probable cause today, there's legally then no reason why to go ahead and delay this for 24 hours.
Well, maybe, I'm not in his headspace. I don't need to be in his headspace. He might be wanting to make other arguments that provide the court more, information regarding bond issues. I don't know.
But the reason from my
bond
experience,
conditions, I don't know. What does it matter?
no, from my experience, it does matter for this reason. If they're looking to bolster their position to hold them no bond, that's where it would negatively affect the defense. That's
Okay,
my
what
position.
if, and
Judge.
what if they are? And what
I don't
if
know,
they
and
are? I'm just
I don't know
asking you.
nothing under the rules of Florida criminal rules of procedure that allows them to extend for that reason.
And that's why I read the rule. It doesn't require a reason. It just says as long as it's within 48 hours, whatever the
That's
reason.
what I'm going to say. I don't think there's anything that prevents it, and I don't think there's anything that allows it. I don't think it's comments on that. Doesn't matter if it's a time issue. It's a timeline issue. It's not a motivation issue.
Well, that's why I was.
It's granted.
There's
Thank
under
you very much.
the rule.
It's granted.
It would be over defense objection, Judge.
That's fine. Thank you.
Okay.
Brandon Samuel Priest. I think this is a change of.
This is the case I provided both Mr. Hodge and Your Honor with a copy of the probable cause affidavit. Your Honor, if I may.
I'm just looking. Excuse me one second.
Whenever your court's ready.
I don't.
That's the one I handed you.
Okay. 1 second. 1 second. Let me just. What's the last name? All I have. Oh, I didn't have it. Excuse me.
That's okay.
Give me 1 second. I didn't
Sure,
have it.
of course.
I didn't look at it. So just give me a moment, please.
Oh, yeah. Oh, thanks. That's for the best. Well, no, I almost forgot. Hold on. We got it. Santana, and we're setting him also.
Okay, thank you. I have reviewed the
Your Honor,
affidavit.
and I could be a little forgetful. Before we move too far along, I was reminded by your deputy, if we could also advise Mr. Santana, because we only had his co-defendant up there, if we could also advise Mr. Santana that his case is going to be reset for tomorrow
Okay,
afternoon.
is he in the main jail or is he somewhere else? Does anybody know?
You're on mute, Hector. I don't know.
Mr. Santana is at the main jail.
Okay, who is Mr. Santana? I'll call him next.
Okay, I just wanted to just. Okay, Your Honor, on Mr. Priest's case, I just wanted to advise, this was downfiled from a burglary with assault or battery to a battery on a person 65 years of age or older.
Yes, sir.
He was being held no bond. This is a bondable offense, so he's entitled to a bond.
Sure.
I just want to advise the court, just so when setting a bond, as you can see, one of his original charges was armed burglary.
I have,
I think it's the last.
committed assault with a deadly weapon without intent to kill, burglary with assault or battery, burglary dwelling, or conveyance armed.
He's being held no bond on that, and that was filed as charged. So
Okay, so on the third, I'm not sure what count that is, but that is a no bond hold?
he's currently being held no bond on that. The only
he
thing,
is?
yeah.
Okay,
So he just needs a bond set on the battery and a person over the age of 65, and whatever the court deems appropriate, I'm fine with that.
All right, thank you very much. 5,000?
I'm fine with that, Your Honor, and a no contact order has already been issued.
Understood. Thank you very much. So 5,000 with regards to count 3. Okay. And I was just gonna, if I can just talk to Mr. Santana for 1 second.
I'm sorry, we didn't hear you, Judge.
Oh, I was just gonna ask to just see Mr. Santana. If we could just come forward a little bit so I can see his face. And let him know that his hearing's gonna be reset for tomorrow afternoon. Thank you, sir.
I understand.
Thank you, sir.
Thank you. And over the defense objection
So
again, Judge.
noted, of course. Thank you.
We just got our second looks in 30 days, I think.
I'm ready. So we're on to the second look docket.
Judge, we only have 2 people here at Maine.
Okay.
We would appreciate if we could call them up.
Yes, of course.
Mr. Wheeler, come on up. Mr. Wheeler, Roger, come on up. The judge is waiting on you. Judge, he's here. He has 2 misdemeanor petty thefts.
So
He's
noted.
asking Your Honor if you would consider resolving his cases today.
If I could check, I don't know that he has 2 petty thefts. Sometimes they'll put it that way in the docket, but it's 2 different offenses. I'll check real quick.
Sure, give us 1 second, please, to verify.
What's that? Okay, but
Meaning
Sheila.
2 separate petty theft cases?
Yes, it is.
What's that pile that you have? Oh, I don't know, I just saw a pile.
Oh, that's just the dockets.
No, that was that it? Did you have a pile or something?
Oh, yeah, this the dispose.
Oh, okay.
Would you like to see the probable cause affidavit on the
Sure. Oh. Okay, so I don't have any objection to resolving this case. Just no return to that Save-A-Lot. I'd offer adjudication on one, withhold on the other.
And I don't see any priors out of Broward for theft, so.
Okay. Sir, did you want to resolve your cases?
Yes, ma'am.
Okay, and just to clarify, is it one case or is it 2 separate cases? 1 case, 2 counts, or 2 separate cases?
I think, let me check in the clerk system to see
This
if you
is
got.
showing me 2 separate counts on 1 case.
I'm gonna check in Odyssey to see how they treated it.
On a 17 case. If that is the case, I'll withhold on both.
Well,
All right.
let me just
And no
confirm.
return to that Save-A-Lot?
Yes, ma'am.
Sure.
Never. Yes.
Yes, it was just treated
Never.
as
Okay.
Never.
one case, two
That's
cases.
fine.
Never.
That's fine. You can convert the cost to a civil uniform. Thank you. They're withholds on both.
Thank you. Withholds on both. You're free to go. Come on up, sir. The next gentleman, sir, Your Honor,
Yes.
is Donald Skinner, and I
Yes.
believe it's a petty theft and a trespass.
Okay.
And he also wishes to ask Your Honor if you will consider resolving his case.
Sure.
Good afternoon, Your Honor.
Hello. Any history I need to be aware of?
Okay. Your Honor, I believe, I'm just checking to confirm. Okay. Yes. I believe the reason that
One second.
Judge Evans didn't resolve this, this arrest occurred about 4 days after he pled out a resisting without violence and trespass before Judge Diaz.
Okay.
And he's also last year had a disorderly intoxication, resisting without violence, another trespass last year.
We're all low level.
Yeah, I'm just.
Okay, you want to resolve your cases so you can.
Yes, Your Honor, I would love to.
Just adjudication on both. Maybe not go back to those locations.
No, I won't go back to that Publix.
All right, you're all set. Thank you very much.
All right, thank you, Your Honor. Thank you, Judge. We're done. You're at me. Have a good day.
Bye. Somebody calling me.
North Broward's got two. Yes, North Broward has two.
Thank you. I'm here.
Come on in, Alan. Alan, I might get it wrong. Mokowskowitz? Is that how it's said?
Moskowitz.
That's very funny.
Yeah, all right. I was close.
I got bills. I got bills. Oh.
All right. It's all right. Give me the run to transportation officer.
All right. Calm down, Alan. She's
Okay,
gonna take care of you,
okay.
okay? She's gonna take care of you.
Alan, do you get benefits?
Yes.
Do you get a check?
Yes.
All right, I'm gonna get you out of jail. Let's get you to the hospital, okay?
Okay.
All right, thank you. Good job.
Okay.
Bye.
The second one is Jarrell. How do you say your last name? Hyacinth.
She knows me, Miss
She
Lauren.
knows you too, huh?
Hi, Miss Lauren.
Listen,
How you doing?
good. You seem like
She's
you're
gonna
doing
she's gonna know me this
okay.
week.
I'm doing great. I'm doing great.
Oh, I'm glad to hear that. Give me 1 second. I'm just let me just write this for Mr. Moskowitz.
Alrighty then.
1 second. He's not well. 1 second. Can you transfer this case to mental health, please? Thanks. All right, I got it. And just maybe fill in the style of the case on top. Name, arrest number. So, on Mr. Hyacinth, what's the nature of the whole?
It's a trespass at a
Do you want to
7-Eleven.
resolve your case, Mr. Hyacinth?
Yes, ma'am.
Do you think you could not go back to that 7-Eleven, please?
Of course I won't go back. Of course.
All right, fabulous. Just a withhold, no adjudication, no conviction, and no return, correct?
Yes, ma'am.
All right, thank you. And that's it. Bye.
All right. Judge Loderin, we're done at North Broward. I will see you Thursday and Friday.
Oh, how exciting. Thank you. That's great. Anybody else anywhere
Conti,
else?
Your Honor. Conti.
Thank you. Hi.
Conti. Hello, we have Harold Davis.
Thank you. Hi, Mr. Davis.
Good evening, Your Honor.
How are you?
I'm well, thank you for asking.
Oh, you bet. Give me 1 second. Anybody have any information?
Judge, let me just see what's going on here.
Dave.
Oh, perfect.
And what is that, ma'am? Madam?
It's a possession of
I'm not
cannabis.
coming down to get it, if that's what you mean.
It's a possession of cannabis, drug
Thank you.
paraphernalia, drug,
Thank you. It's a possession of cannabis. The offer's a withhold.
and a drug paraphernalia.
And offers a withhold, and I'll take judicial notice of time served. Did you want to resolve your case today by way of a plea of no contest?
Yes, I do, Your Honor.
All right, then you're all set. Thank you very much.
Thank you, Your Honor.
Davis.
You're welcome.
We have Noah Sighthammer.
Noah what?
Sighthammer?
Is that accurate?
Yep, that's correct.
It's CEITHAMER.
Behind him here.
It's battery.
Oh, I can't resolve that. I'm not comfortable. There's a victim related to this offense. So who is the division judge?
That's what I'm checking to see right now.
Could you get him set before his division judge, Madam Clerk? Please. It's really appropriate for his division judge. You know, there used to be an administrative order that magistrates couldn't resolve better.
And
Your Honor,
it's not so much here for resolution.
It's not.
It's covered by the
One second.
it's covered by the administrative order technically to see about if anything could be done with the bond that was set. But I can tell you, Judge, $1,000 bond was set, which is the convenience bond. Mr. Sighthammer's, it shows on the booking that his address is Wisconsin, so it appears that if there are any ties to the community, it's limited. One moment.
that
Your
is
Honor.
correct.
So I mean,
That
I
is
think
correct. That's why I haven't been able to post my bond yet.
What about family?
I don't have very much contact with family anymore, unfortunately. So, yeah, but I don't believe that I caused any bodily harm. I
Okay,
think
but
I was
don't
just trying
comment
to.
about your case, okay? Because
Oh,
anything that you
absolutely,
say
I'm
could
sorry.
be used against you. You really need
I
to get.
apologize.
No, you didn't do anything wrong. You need to get in front of your division judge, and I'm sure that you have a lawyer, right?
No, I don't. Well, I have an attorney through the
Public defender?
public defender.
They're
Correct.
great
Yeah.
lawyers.
Okay.
You have a great lawyer. All right? So we'll get you in front of your judge, okay?
Okay.
Thank you.
Thank you.
You're welcome.
We got John Pace.
this is also a battery that Judge Evans heard last week. One moment, Judge.
Are these cases already charged?
No, this is another second look. He was just arrested about the 27th. I can tell you.
Again, there's constitutional rights that flow to victims.
Oh, and as far as pleading out, of course, I just wanted to let you know the facts at the regards to the
I don't
bond.
need to know
Okay,
That needs to be.
That's before assigned to
he's
judge-
gonna- I think, sir, it sounds like the case is pending. Is that accurate?
yes, it's assigned to Judge Pohl.
I don't have the bond. I'll never have the bond money. I don't have any family or friends that could help me. I don't have the money.
All right, well,
I've been out of work.
he really needs to get in front of his division judge. I am really uncomfortable. I'm not going, I really don't want to address matters of batteries in this
Understand.
division. There's victims' rights at stake, and they're just as paramount as his rights under the Constitution. Thank you. I'm going to have you set before Judge Paul. Thank you.
Yes, ma'am. I don't have a public defender as
I'll
well.
appoint you a public defender provisionally. Thank you.
Okay. How long do you think I'll be waiting to go to court?
Not very long at all. I'm going to ask the clerk's office to accelerate it.
I appreciate that, ma'am.
Alrighty, thank you.
And our last person is Travis Cooney.
That's a motion to release on a
Okay,
felony.
motion to release, yes.
I'm just going to check to see if information was
second,
filed.
On that early representation unit, David, could I provisionally appoint through the early representation unit?
Yes, ma'am, I'll draft an order.
All right, great.
Your Honor, information was filed as charged for aggravated assault with a deadly weapon.
Thank you. Sir, you heard the news, correct? I don't have to repeat it, all right?
Yes.
All right, thank you. Thank you very much. You'll be seen
That's
in your
it, ma'am.
division
Thank
judge.
you.
Of course, thank you all very much. It's denied, of course.
That's the judge.
Yes, of course. Oh, that's okay.
I don't want to overstep.
Yes. I'm sorry, the gentleman I just spoke before,
No,
Judge.
That was John Pace, the battery, yes.
All right, thank you all very much.
I think we got a few more cases, Judge.
Anybody in any
I
other
think at Paul Ryan.
venue? Paul Ryan? Madams, anybody?
Yes, Paul Ryan.
Okay, we're
We have
there.
three.
Three, thank you.
Williams, Miss Williams.
Come on up, madam.
Whichever's better for you.
Williams, Miss Williams?
Yes, yes.
All right, thank you. Give us one
It's a
second.
prostitution case, Judge.
Okay. Were you interested in resolving your case?
Yes. Yes, ma'am, I am.
Okay. If you'd like to resolve your case, do you have any objection on the state level? I'd offer you a withholding of adjudication, no conviction. There is a relatively hefty cost for court costs. I think it's what, 6? Anybody?
Right. Yeah, that's what it comes down to.
Do
If
we
it,
know the statute? There's no information?
I can. Oh no, definitely. There's not been an information filed.
So when there's no information,
They're gonna go by what she's been booked on. But
is it-
isn't the one with the really huge fine the solicitation one? It's this. I believe it's. Considering why they put it in place, I believe it's a solicitation. Let me check
1 second, we're trying
real
to figure
quick.
Yeah.
They charged her with the E subsection, Judge, which is not the soliciting.
Okay, good. So anyway, if you'd like to resolve your case, you can. The offer of sentence is a withholding of adjudication, no adjudication. The statute does require that you provide proof, not the results, but proof that you have an HIV STD blood screen. So that could be from a clinic, any healthcare provider, but not the results. Those are private information to you, correct? Just a receipt or something like that within 60 days. All right?
Yes, ma'am.
Okay.
Yes.
And the court costs, anybody? $293. I could give you 6 months to pay, okay?
Okay, thank you.
You're welcome. Anybody else? You can have a seat.
Okay.
Well, let's.
I've got another
We can take care of it.
What is your name?
Brooke Price.
Bryce.
Brooke Price. She was charged with a little bit of a different statute, but it's still not the F subsection.
Assignation.
It is. She was charged with technically receiving into a building for prostitution, and Judge Evans in his comments wrote offer to secure. I'm showing it is
He wrote what in his
offer to secure.
Offer to secure.
Yeah. I'm sorry, I just lost it for a second. It was under section 2C2.
Okay.
And Your Honor, and what I would put on the record is if for some reason that was imposed, I would have no objection to vacating and resentencing because it's not the intent in this matter.
Understood, of course. But you're saying you think it's the lower costs?
Yes, because I believe the clerk is right when you said subsection F, correct? Yes, this is not.
If you want to resolve your
Subsection F.
case today, you can. Same offer, withholding of adjudication, no conviction. The HIV STD screen, not the results. That's private to you. Within 60 days, and I'll give you 6 months for court costs of $293.
Okay, ma'am. Does that mean that tomorrow are?
No, it doesn't. It means that I'm offering you a plea.
Yes,
I'm
I'll
offering
take
you a
that plea.
plea.
Yes, I'll take that plea.
Understood. Right. Meaning the case will be over. You'd be waiving and giving up any of your constitutional rights, and you would not be disputing the charge. You know, there's nothing to dispute after the case is over. It's final, unless, of course, there was the state's indicating if they made some kind of, not a mistake, but if it turned out that the charge was not what they thought that it was. We can come back, but I think it's fine. Understood?
Okay.
All right, thank you. You're all set.
Is that it? Yeah, I see Sandrella Henley. Is she there?
There's one more there.
I didn't see any.
Miss Henley, she's medical reset, Your Honor.
That's right.
Oh, medical reset. Okay, thank you.
Yes, ma'am. Yes.
And
All right.
Anybody?
he bonded.
Oh, bonded.
No. Gary Oberus. He bonded.
All right, I think that's it, y'all.
There is one other case. I'm gonna check that. Yeah, let me check. They might not have pulled him, but I'm sure if they didn't pull him, I'm sure Mr. Hodge will waive his appearance.
There's nobody else there.
I'm just checking to see if he's still in custody, Your Honor. Timothy Foreman. Okay. Yeah, he said Paul Ryan.
Could you put him on for the morning?
Well, Your Honor, it's a motion to release. I don't have if Mr. Hodge doesn't have an issue, I don't have an objection to waiving his appearance and having the order signed. I can tell you. Charges have not yet been filed, so he is entitled to an ROR today.
Okay, that defendant is entitled to release on Mr. Foreman. Thank you all very much. I'll see you in the morning.
Sounds good, Judge.
Good job.